Carls, and today I am here with Joanna Fraczek, one of our attorneys in our Milwaukee office. And today we're going to be talking about the topic of life insurance as it relates to life insurance in a divorce. So, Joanna, thanks for joining me today.
My pleasure.
One of the questions we get from our clients online is what happens in a divorce when a life insurance policy is involved. So, generally, what happens in that scenario?
Sure. Generally, while divorce is pending, no one should make any changes to beneficiaries on any kind of policy, including life insurance policy. So while the divorce is pending, don't change your beneficiaries. Usually, in terms of final divorce agreement or final divorce order, ex-spouse is removed as a beneficiary. If there are children, minor children, usually they are replacing the former spouse. There are some situations where court would ask or people would agree that a former spouse will continue as a beneficiary on that life insurance policy. Usually those situations happen when the beneficiary on life insurance policy, ex-spouse, is also receiving either maintenance payment or child support payment, and that's just a mechanism to ensure that in case one spouse dies, then his or her life insurance policy would cover for those lost payments in maintenance or child support. So that's the rationale behind making those exceptions and keeping former spouse as a beneficiary on life insurance policy.
So, in instances where, I'm going to make the assumption that sometimes there's instances where the spouse is kept on as a beneficiary even outside of those circumstances. If that is the case, kind of what happens if that court order isn't maintained, or that one spouse that is ordered to keep that ex on as a beneficiary in the circumstances you identified, or that was just something that they agreed upon at the time of divorce? If that's violated, kind of what happens, or what would happen in that scenario?
So it happened once before, at least once. And that one instance was a case between Washington and Hicks. In that case, judge made rulings and gave precedent to how we resolve those issues. So in 1982, this case came before our Wisconsin Court of Appeals for decision. And Mr. Hicks was married to his ex-woman. There are two spouses. Mr. Hicks was a policy holder. He was supposed to keep his wife, then ex-wife, on his policy as a beneficiary, and he was not supposed to remove her. Well, he did remove her as a beneficiary. He remarried and put his current new wife as a beneficiary in place of his ex-wife. Subsequently, he got in a car accident and he passed away. Well, now both wives went to court with variety of questions, but for our purposes, the most important questions that were answered were the following. What happens when, say, husband is supposed to maintain his ex-wife as a beneficiary, but he doesn't? Mm-hmm. Is she entitled to that payment? Court says yes, she was entitled to payment, even though she was not listed as a beneficiary as at the time of his death. Second question is, what amount was she entitled to? At the time of divorce, their final divorce order specified what this amount was supposed to be. Over time, his policy value increased. So ex-wife was arguing that she is entitled to that current amount. Court said, no, you are entitled to what was agreed upon during divorce. So those are the two most important takeaways from that case.
Awesome. So in practical terms, so what people going through a divorce or having to look at that as a potential reality, what are some of the practical things that they should really be thinking about in before going through that process, if there's a life insurance policy that's at stake.
One very important practical approach is to always be sure what is the policy of that life insurance. Regardless of what family court order says at the end of divorce, it is going to be the policy of life insurance carrier that governs. It is, and I'm saying it's important to check in advance because policies vary and carriers take different approaches. Some of them won't make any adjustments upon the divorce, and other policy carriers will explicitly say that upon a divorce, ex-spouse is automatically removed as a beneficiary. So it is important to be aware of policy terms, just so we don't draft an agreement, divorce agreement, that would say something opposite to what the policy is, and then invite problems and
Right.
court and lawsuits.
So in the case that you cited, it sounds like that policy didn't automatically opt out the spouse, presumably.
Presumably, it was not addressed in the language of the case.
But if that policy had said that specifically in that case, and that happened again, she may not have a claim if they didn't read they didn't read the policy, and the policy said upon divorce the ex-spouse will be removed.
I'd say it's safe to assume that that's the case, and I'm almost certain that it has happened more than once since 1982, because this trend with policyholders is increasing now. So just like with health insurance policies, carriers oftentimes make provisions upon legal separation. We don't need to go into this right now, but policy carriers start recognizing what people do, and they try to be ahead of the game, so they're tightening up their policies. So it's becoming more and more prevalent that policy carriers will put that provision in place.
Awesome. Well, thank you very much, Joanna. Appreciate it.
Thank you,
everybody.
Case Law Friday is a Sterling series focused on communicating in layman's terms, cases of precedent, statutes that guide decisions, and court procedures important to getting results in family law. Please like and subscribe. We hope these deep dive conversations create clarity, enabling you to better understand the rules that govern how decisions get made in family court.